personal injury claim, no win no pay, auto accidents, insurance claims, slip and fall, wrongful death. We can help you. Formidable team. Dr. Olu Asekun, Olu Asekun, Marisa Ifaragueri, Irene Inocencio, Kimberly Swiglow, Cristal Diaz, no win no pay. Call us today at telephone number 817-891-6655. 817-891-6655. The Law Office of Olu Asekun, PC. Personal injury claim, no win no pay, auto accidents, insurance claims, slip and fall, wrongful death. We can help you. Formidable team. Dr. Olu Asekun, Olu Asekun, Marisa Ifaragueri, Irene Inocencio, Kimberly Swiglow, Cristal Diaz, no win no pay. Call us today at telephone number 817-891-6655. 817-891-6655. The Law Office of Olu Asekun.
Are you involved in an accident that wasn't your fault? The Law Office of Olu Asekun can help. No payment until we win. Call us now at 817-891-6655. That's 817-891-6655. Are you involved in an accident that wasn't your fault? The Law Office of Olu Asekun can help. No payment until we win. Call us now at 817-891-6655. That's 817-891-6655. Are you involved in
helping you with your tax return? Are you sure they are doing it correctly? You don't need to file tax amendment. Fair Deal Tax Services can help you. Personal income tax returns, business tax returns. Contact us today. 817-274-1144 extension 602, 817-274-1844 extension 603, 817-891-6655. Who is helping you with your tax return? Are you sure they are doing it correctly? You don't need to file tax amendment. Fair Deal personal income tax returns, business tax returns. Contact us today. 817-274-1144 extension 602, 817-274-1844 extension 603, 817-891-6655. Who is helping you with your tax return?
Translation services? We provide translation in the following language pairs: Spanish to English, English to Spanish, French to Spanish, French to English. We specialize in the following fields: immigration, legal, technical, school certificates, documents of a general nature. We also offer proofreading and notary public services. Contact us today via phone, text, or WhatsApp for a free estimate at 817-707-3593 or by email at infotranslationsyahoo.com. Do you need
And Simi Asekun Foundation. We are doing lots of great works in Nigeria. Law Resource Center. Essa Baby Asekun Badmus Indigent Fund. Annual Rashid Asekun Destiny Helper Award. Annual Simisola Asekun Moot Court Competition.
So it's no longer 6 p.m. Nigerian time. I believe it should be, is it 5 now or 6? How do you calculate? No, I know it's 7 hours. What would that be in Nigeria now?
What time it is for now?
7 p.m. Okay. Okay. So it's now 7 p.m. Nigerian time. So welcome to our podcast. So it's now 7 p.m. Nigerian time. So welcome to. Oh, okay. Is it okay now? Dr. Olu, there are two types of visas. We have immigrant visas and we have non-immigrant visas. For immigrant visas, they are not discretionary. They cannot be denied except there is a valid reason. And even when they are denied, the consulate will recommend revocation back to USCIS, and USCIS will give the petitioner an opportunity to respond. They will give what is called notice of intent to revoke, and then the petitioner will have an opportunity to present their own side of the story. So that is an immigrant visa. But when it comes to non-immigrant visas, we have to understand that that one is 100% discretionary. So non-immigrant visas can be denied with or without reasons. They could be denied for no reasons. So that is what that simply means. It is 100% discretionary. So if you have questions regarding visa questions. Send in your question. We are treating visa questions today. And like I said, today is like an open buffet. So we are not limiting it to one particular kind of visa. So any form of visa questions that you may have, here is an opportunity to ask those questions so that I can explain it and break it down. So send in your questions. Also remember to invite your family and friends so that they can also benefit from this. Send in your questions today. We are treating general visa questions. Any questions so far? Okay, so send in your questions. We are treating general visa questions today. Questions relating to visas. So whether you have been denied visa, whether you have a kind of visa, you want to know what you can do and what you cannot. Open platform today. Send in your questions, visa questions. Okay, I think questions are beginning to come in. Okay, the first question is, what kind of occupation qualifies for H-1B visa? Okay, first and foremost, our listeners may not understand what is H-1B visa. H-1B visa is a temporary employment visa, temporary working visa. It requires a petitioner, a US-based petitioner, a US-based employer to petition for the beneficiary. However, for H-1B visa, the minimum requirement is 4-year degree. It is called baccalaureate degree, 4-year degree, because it is considered a skilled worker. H-1B is called specialized occupation, specialty occupation. So it's a kind of visa, it's a kind of working visa that requires a minimum of bachelor's degree, 4-year bachelor degree. That is the minimum. Associate degree is not eligible for H-1B visa. It is only a bachelor's degree, at least a degree that requires 4-year full-time study. That is what qualifies for H-1B. And you need an employer, a US-based employer, who will file the petition on behalf of the beneficiary. I believe that we have treated H-1B on this platform. So if you have additional questions regarding H-1B, how it works, you can search our channel. We have treated H-1B as a separate topic. Today, we are only discussing general visa questions. Okay, the next question. Can a J1 visa holder work while in the US? Oh yes, J1 is authorized to work. They are given Social Security. They can work in the US. But of course, they have to work for the sponsor. They have to work for the petitioner, whoever sponsored the J1. Yeah, they can work. J1 is not a visiting visa. It's not a tourist visa. It's actually a visa that authorized employment. The next question. Is it possible to receive a tax refund while on J1? Yeah, if you file your tax and you are eligible for a refund, yes, you will get your tax refund. Yeah. If you are on J1, anybody making income in the United States is required to file tax return. So if you are making money on a J1, either if you are making money, the next question. Can a J1 visa holder apply for a green card? No. A J1 visa requires the beneficiary to return back to his or her home country at the end of the authorized period for a minimum of 2 years. That is what is called 2-year foreign residency requirement. So a J1 visa holder cannot apply for green card except in limited situations. And of course, if you want to know more about J1, you can search our channel. We have discuss J1 as a separate topic. You can get more information on J1. The next question: can my spouse and children come to the US with me if I have H-1B status? Oh yes, H-1B status authorized dependent, wife and children, or spouse and children. Yes, they can come. While you will be on H-1 status, they will be on H-4 status. That will be for the dependent. And when they are on H-4, they may not be able to work, but they are legal and your children can go to school on H-4 status. Yes. For O1 visa, who qualify as an alien of extraordinary ability? Well, as you have stated in the question, it requires extraordinary ability, which means that you must have something that is unique, something that an average American does not have. You must have some special skills, some special talent. You must have some something you are bringing to the table, which is not for general employment. It's not like the general employment cases. You have to show special skill. You have to show that in your field, you are one of the top 1% in your field. You have to show what you are bringing to the table. You have to show unique capabilities. You have to show that there is something special about you in order to be eligible for O1 visa. May O1 visa have dual intent? Can the alien do the other work beside the identified event from the petition? No, H-1B visa is the only dual intent visa. H-1B visa is the only dual intent visa. Sponsor it. Different agencies do sponsor it. For as long as they have something for you to do, of course, and government can sponsor it as well. So there is no limit to who can sponsor it. The next question: how do I know if there are visas available in my category, and can you explain the visa bulletin? Well, for visa bulletin, it is released by the Department of State once a month. So for easy accessibility, I will advise you to go through Google so as not to complicate it, because if I tell you otherwise, it may be more difficult to access. But the easiest way is just go on Google and search current visa bulletin. But when you do, please select the option that comes from the Department of State, because there are so many private organizations who are duping people, who are making money out of people. They can tell you all kinds of things. They can ask you to make payments so that they can alert you. All those things, they are fraud. Please don't fall victim of fraud. If you search current visa bulletin on the Department of State, on Google, select the one that comes from the Department of State. So once you select that, that is a reliable information. It is the Department of State that determines where immigration is, or where the U.S. government is generally on an annual visa basis. Now, what is visa bulletin? Because there are every single employment-based visas and some family-based visas, they all have limited number of applications that can be approved annually. There are statutory limit to the number of green cards, to the number of petitions that can be approved annually. Now, the Congress gave the Department of State the responsibility to monitor where they are on the numbers. For example, if employment-based, EB1, if they can only approve 30,000 green cards per year, it is the Department of State that monitors it. Okay, we are in November. How many has been approved so far? How many is still pending? When is the 30,000 exhausted? When can someone submit a petition based on the available number? When is somebody's turn? When is it going to be your turn? Every petition that is filed, when immigration issues a receipt notice, when it comes to visa bulletin, that receipt notice, the date that your application or petition was received, that is the date that is called priority date. That is the date that you join the queue. So now, when you check the visa bulletin, you look at what date are they processing. For example, let's say as an employer, let's say my law office filed an immigrant petition for a prospective beneficiary, or let's say somebody filed a self-petition, EB2, for himself or herself. Now, let's say the petition was received by immigration on January 15, 2023. So when you go to visa bulletin, when you go to the Department of State to check the visa bulletin, you go under EB2. Under EB2, where are they right now? So when you see where they are, they will tell you, oh, we are currently processing cases that were submitted maybe June 2022. Meanwhile, your own petition was received January 15. So that means that for you, visa is not current. So you have to keep checking every month until they get to cases that were received on January 15. That is when your visa becomes current, and that is when you can apply for green card based on that petition that you filed or that was approved on your behalf. The next question. Okay, the next question. Does someone need an employer when petitioning for EB2 national interest waiver? No, you don't need an employer. EB2 national interest waiver is a self-petition, is a form of self-petition. So if you are eligible, you don't need anyone to sponsor you. You are exempt from the requirement of a sponsor. You are also exempt from the requirement of labor certification. So it's a self-sponsored petition. The next question. What is ETSA? Yeah, but the question is ETSA. I know it's ESTA. Can I use it in place of a visa? What is the procedure for this process? Well, there are some countries that have a kind of relationship with the United States where they have visa reciprocity. What that means is that if you are a citizen of such a country, you can enter the United States without a visa. It is called visa waiver countries. Countries like England, I believe Germany too, Canada. There are some countries that can come to the United States without a visa. United States citizens can also go to those countries without a need for a visa. Now, that is what is called visa waiver. However, there are rules and regulations with visa waiver, with ESTAs. Number one, if you enter the United States on a visa waiver, you can only stay a maximum of 90 days. Maximum of 90 days. You cannot extend it. It is not a visa that you can extend. It is called visa waiver because they expect that you are coming in temporarily just to do something so temporary. So 90 days is a lot of time. That is 3 months. So you cannot stay more than 3 months. If you stay beyond 3 months, you will be violating your status. Secondly, you cannot adjust your status or you cannot change your status if you come in with a visa waiver. You cannot change your status. That is, you cannot come in with a visa waiver and then say, oh, you know what, I want to go to school. Let me change to F1. It is not allowed. You cannot do a lot of things. There are rules and regulations. However, there are exceptions. The fact that you come in with a visa waiver does not stop you from getting married to a U.S. citizen. It doesn't stop you from applying for adjustment if you are eligible, but it may not allow you to change your status if you are in the United States, but may allow you to adjust your status to that of a legal permanent resident if you are eligible. The next question. Do I need to be vaccinated against COVID-19 in order to obtain a visa into the U.S.? Well, I'm not current on this. I don't know the specific answer right now. I don't think it's a requirement, but I'm not 100% sure. I don't want to give information that I'm not 100% sure. Whatever information you get on this program, I want you to you can go to the bank with it. It's authentic. But this particular one, I'm not 100% sure. I don't know whether the embassies are requiring it. I don't think so, but I'm not sure. Because even in the US now, to be vaccinated is completely your option. However, if you are going to apply for green card, you have to be vaccinated. It's a mandatory requirement if you are going to be applying for green card. That may be different if you are applying for visiting visa or any kind of non-immigrant visa. But as far as immigrant visa is concerned, I am 1,000% sure that you will be denied if you are not vaccinated. If you are applying for an immigrant visa, there is no way around it. The next question. I am the child of a foreign national. Do I need to apply for a visa in order to travel to the US? I'm not sure I understand the question. I'm a child of a foreign national. What does that mean? Maybe whoever sent this can clarify it. I don't understand it. I'm a child of a foreign national. Do I need to apply for a visa in order to travel to the US? Well, to the best of my knowledge, every non-citizen, everyone who is not a US citizen, will need to apply for a visa to come to the US, except if you are from a visa waiver country. The next question. B1 visa is visiting for business. Does that mean that I can do business in the US and make an income in the US while visiting? Well, it depends on the nature of business. When you are talking about coming in for business, of course, people come in to negotiate contract. People come in to sign contract. People come in to discuss partnership deals. People come in to discuss foreign investment opportunities. There are so many things that you can do on a business, but you are not allowed to obtain employment. You cannot start looking for employment on a B1, B2 visa, but you can discuss business. Yes, you can come in. Maybe you have a company in your home country and you are looking for an opportunity to have a partnership deal with an American company. So you can come in, you can attend conferences, you can attend a meeting with this company, you can sign partnership deals, you can discuss business opportunities, you can do businesses together, you can discuss any. What you cannot do is to take up paid employment. The fact that you came in with a visiting visa for business does not authorize you to take up paid employment. You cannot. That will be a violation of your status. Of course, before I go to the next question, of course, you can discuss business and make money even without living here. Yes, you can do that. For example, you can come in on a B1 visa, and then maybe you do some investment, or maybe you, for example, you can purchase a property, and then maybe subsequently, if you decide to sell the property and you make money out of it, maybe you have to pay what is called capital gain tax. So you still have a responsibility, even though you don't live here, even though you don't have social security, you still have a responsibility to file your taxes. So you have to file the tax, report the income that you make, even if the government is not going to tax you, especially if they know that you are still going to pay tax in your home country, but you still have to file. The responsibility to file tax is different from the responsibility to pay tax. They are not the same. So as a foreigner, your responsibility is to file taxes. So even if taxes are due, you may not need to pay if there is evidence that you are still going to pay the tax in your home country. So you cannot be taxed multiple times. But the obligation to file taxes is mandatory. That one is mandatory. You have to file the taxes. So it's many foreigners who file taxes here every year, and yet they have never paid $1 in taxes. So filing taxes is different from paying taxes. The next question. I applied for visiting visa 1 year ago and they did not grant it. How soon can I reapply? Well, as I stated at the beginning of this program, visiting visa is 100% discretionary. In fact, every non-immigrant visa is 100% discretionary. There is no time limit to when you can reapply, because you could be denied visa for no reason. And you could be denied visa for reasons that you may not know. For example, I've seen someone who has been coming to the US for years, yet he went to the embassy to renew his visa, and without even asking a single question, they just told him, sorry, your visa is denied. And he was like, you have not even asked me any question. The officer said, go and reapply. Of course, he was furious. He was angry. Why would you deny me without even asking questions and all of that? He was furious. Then he called me, and I advised him to follow the officer's advice. Go back and apply. So he reapplied. Of course, to get an appointment is usually not easy in some countries. So for him to get an appointment, it took him another 2 months. So after 2 months, he went back. Unfortunately, this time, the same way they didn't ask him any question when they denied him, they also did not ask him any question, but they gave him the visa this time. So that is just to tell you the power in the discretion, the discretionary authority of the consular officers. And again, I can't blame them because they derive their authority from the Congress. So there is nothing anybody can do about it. There is no lawyer that can influence it. If any lawyer is promising you, I can do this, I can do that, they are just fake. They are trying to defraud you. There is nothing. Not even American president can change it. If they deny you visa, there is nothing President Biden can do about it, because the consular officers derive their authority from the Congress. So except the Congress change the law, right now, the law is that non-immigrant visas are discretionary. And the court have stated multiple times that you cannot force somebody to use his or her discretion one way or the other. The moment you are able to do that, it is no longer discretionary authority. In this case, what was granted to the consular officers are discretionary authority. So there's really nothing you can do about it. So there's no time limit. If they deny you, just look for additional evidence, additional reason to overcome the reason for denial, and go back and reapply. You can reapply the following month. You can reapply 2 months after. You can reapply 1 year after. There is no time limit. What matters is looking for evidence to overcome the reason for denial. The next question. My visa to visit the US was denied, and I don't know why. What can be done? Well, this question is not explanatory enough. I don't know if this person has ever been issued visa, if this person has ever visited the US, if this was a first attempt, or if this person has never been granted a visa. The reason is that if this person has visited the US before, has been coming to the US, and then you are denied visa, then we can do what is called FOIA. We can do a FOIA and find out the information in your record under the Freedom of Information. But if this person has never visited the US, then there will be no record. So there can be no FOIA. So that is one of the reasons why we need to know, to have more information. So if this person has been to the US before or has been granted visa before, then you can do FOIA to find out why this visa was denied. So once you know the reason why the visa is denied, then you can know how to prepare when next you reapply. The next question. My passport will expire while I'm in the US. Is that a problem? No, it's not a problem. Well, it depends, because I don't think it's a problem, even though this person didn't stay in the country, but it is not a problem because your passport really has nothing to do with your stay in the US. What determines your stay in the US is the I-94 granted to you. The I-94 granted to you is what determines your stay in the US. If your passport expires, depending on your country, usually you should be able to travel to your home country with your passport if you are flying direct. The only problem will be if you have to go through another country. For example, if you are from, let's say you are from Ghana and you are in the US, your I-94, you are given 6 months. Let's say your I-94 is going to expire December. We are still in November, but now your passport is expired. You have two options. You can go to the Ghanaian consulate in the US and apply for travel document so that you'll be able to go back to your home country. The other option is if there is a direct flight from the US to your home country, then you don't need to bother yourself about getting travel permit or even renewing your visa, because airlines will still take you to your home country for as long as they are not passing through or stopping in another country. But if they are going to stop in another country, you will need to renew your passport, or you need to get what is called travel document from the US and from the consulate of your country in the US. The next question. Can someone petition for themselves for an O1 visa? Well, O1 visa is a non-immigrant visa. It is not an immigrant visa. Usually, for O1 visa, you need a sponsor. But somebody who is eligible for O1 visa may be B2 category, not under O visa. You cannot do O visa, requires an employer to sponsor because it's a temporary kind of visa. The next question. What is the difference between obtaining visa through consular processing versus changing status in the US? Well, the difference is very clear. When you are physically present in the US and you want to apply for a change of status in the US without going back home, that is what you can do in the US. It can be either a change of status for non-immigrant visa or adjustment of status for immigrant visa. It requires that you must be physically present in the US. On the other hand, consular processing means that you are outside the US and you have to go through the US embassy. So again, it can be non-immigrant visa, it can also be an immigrant visa. For example, H-1B, you can find an employer who is willing to employ you on a temporary basis. They submit H-1B petition on your behalf. That petition was approved. If you are physically in the US, you can change your status to H-1B. If you are outside the US, you can apply for H-1B through the embassy. That is what is called consular processing. But in the case of immigrant petition, it is the same thing. So the petition has to be approved first. If you are in the US, you may, in the case of some petitions, you may be able to file concurrently. That is, the petition together with the application for green card, you may be able to file both of them together. But if you are outside the US, concurrent filing is not possible with consular processing. So that means you have to wait for the petition to be approved first. Once the petition is approved, you now process your green card through the embassy, of course, through the National Visa Center. So the difference is basically you are doing one from outside the US, which is consular processing, and the other one, you are doing it inside the US, which is either a change of status or adjustment of status. The next question. I want to apply for student visa. Can I seek admission to any university? Well, you cannot seek admission to any university. If you are going to apply for a student visa, you have to be admitted to a university or college that is authorized to issue I-20. If you apply to a university that does not have the authority to issue I-20, your admission may not be, you will not be able to change to F1 status. F1 status is only possible if you get admission from a college or university that is authorized to issue I-20. I-20 is the document that the university will issue giving you admission, which is permitted to be used to either apply for visa or apply for a change of status in the US. So if the school you apply to does not have the authority to issue I-20, then you cannot get to F1 visa, because every school that is authorized to issue I-20, they are authorized by ICE, Immigration and Customs Enforcement, and it is not every university in the US or every college in the US that has that authority. It is, in fact, from time to time, ICE do revoke authority even from schools that were permitted. It can be revoked. So before you start the process, you have to check it out and be sure that the school you are applying to is actually authorized to issue I-20. Otherwise, it will be an exercise in futility. The next question. I'm a citizen. What can I do to fasten my children's visa? It's been with NVC for 2 years. Well, this person, I'm assuming that you have received a letter, an email from the NVC stating that your case has been documentarily qualified, because if you have not received that letter, you have not even started, because that is the first thing that has to be resolved. You have to, if you have not received the email from the National Visa Center telling you that the case has been documentarily qualified, it means that you are still missing one document or the other from the NVC. So my first advice is log into your portal with the NVC and verify that there is nothing missing in your case. Because if a document is missing, All the NVC is going to do is to upload the portal, nothing more than that. So if you don't act on it, it can be there for the next 2-3 years. In fact, after some time, the NVC will just send you notice of revocation or notice of cancellation of the visa. So you have to be sure that no document is missing. Now, if you have received the email from the NVC telling you that your case is documentarily qualified, in that case, you can go ahead and request for expedited processing, assuming that you are eligible for it. For example, it depends on the ages of these children. It depends on their situation in your home country. It depends on a number of things. So I will advise you, go to the Department of State website and check the requirement for expedited processing. So if you meet the requirement, submit a request for expedited processing to the NVC. Usually, there has been a lot of delay since COVID started, since 2020 when COVID started. There has been lot of delays, primarily not from NVC, but from the US embassies all over the world. So once NVC finishes the process of documentation, they have to wait for the US embassy in the home country to give them available immigrant visa dates. And these dates are becoming more and more difficult to get because of the backlog created by COVID in 2020 and by subsequent government policies. And of course, in some cases, and in some countries like Nigeria, the problem started even before COVID. We all remember when President Donald Trump was the president of the United States, he had this travel ban on Nigeria and some other countries. So the backlog started since that era. And of course, things are processed in the order in which they are received. So all the backlog that were created at that time, coupled with the additional backlog created by COVID, so the embassy have to clear all of that before they can treat new cases. So these are some of the things that created additional processing time backlog. But again, review the requirement of expedited processing. If you are eligible, submit a request to the NVC for expedited processing of your case. The next question. Please, my attorney have filed for an appeal for I-130 for a year now, and anytime I check on the EOIR case, found this A number. What should I do? I'm from Ghana but living in North Carolina. I'm not sure I understand the question here. The attorney has filed for an appeal. Anytime I check, I found this A number. Oh, okay. Anytime I check on the UR case, okay, I found no. Okay, please, my attorney have filed for an appeal for I-130 for a year now, and anytime I check on the UR case automated case system, it says no case found for this A number. What should I do? Oh, okay. Yeah, I understand the question now. Number one, your appeal, when an I-130 is denied and an appeal is filed, it is filed with the BIA, Board of Immigration Appeals. And when you are checking EOIR, you are checking Executive Office of Immigration Review. They are not the same thing. So the EOIR, that is the court system. Although the BIA is part of EOIR, the issue is that I-130 decision that came from USCIS, that is administrative appeal, it goes to BIA. It doesn't go through EOIR. So the EOIR you are checking, that is the court system. That is that is meant for people who are in removal proceedings, people who are in what some people call deportation proceedings. So if you have never been in removal proceedings, if you have never been in deportation proceedings, you are not going to get anything from the EOIR website. So that is not the purpose. The purpose is for those who are in removal proceedings, is for them to check their next court date. The judge who is handling their case, processing information about their case. That is what that EOIR case information system is for. It is not meant for appeal from the immigration office. Appeals from the immigration office goes to BIA. It doesn't go through the EOIR system. So if you want to know the status of your appeal, you have to call BIA and find out the status from them. You cannot get that status from the EOIR website that you are looking at. That one is meant specifically for people who are in removal proceedings. The next question: is there a way to extend my visa after it has expired? If not, how can I rectify it? Well, I'm assuming, well, don't let me assume. There's a difference between a visa and status. So if this person is talking of a specific visa, visas are not issued in the United States. So if your visa expired, you will need to step out of the US to go and extend your visa. On the other hand, if you are talking about your status, if your status is about to expire, you can submit an application to extend your status, but that application must be submitted before the expiration. For example, let's say somebody came in with a visiting visa. If at the port of entry they gave you 6 months, let's say the 6 months is going to expire next February. If your visa expires this November, you are not affected in any way because your legal status is still valid until February. However, you cannot extend your visa in the US. You can be here until February legally, but you cannot change to F1 visa or H1B visa or status. If your H1B is about to expire, because H1B is a status, you can apply to extend it, but the application to extend it must be submitted before the expiration. So let's say your H1B is going to expire in February next year. You have to submit an application to extend it before February. That one you can extend in the US. But even when it is approved, what is going to be approved is your I-94. They are not going to give you a new visa. If you need a visa, you will still need to step out of the country, go to a US embassy outside the US, and then apply for. Well, this must probably be an old version. They don't turn in any I-94 anymore because right now, I-94 is electronic. You don't need to turn in anything. Once you left the US through an airport, immigration already have your record that you departed. So there is nothing to turn in. However, if you didn't go through an airport, if you drove out of the US, then you need to submit your I-94 at the port of entry or exit, because that way they may not have the record of your departure. Usually, the electronic I-94s, they are connected with airlines. So if you are leaving the US and okay, I got clarity on that question. Again, like I said, it is not applicable to every country because right now there are electronic I-94. I-94s are no longer in paper form or card form. They are electronically issued, and when you leave the United States, there's always a record that you have departed. However, if you are from one of those countries, either you are from Canada or you are from Mexico, and you did not go through airport, you drove out of the US and you did not submit your I-94, the card, the I-94 card that is given to you, what I will advise to you to do is to look for documentary evidence that will show your physical presence in your home country, and then attach that documentary evidence together with the I-94 and mail it to ICE office. Usually there is an address that will be provided. I believe it should be at the back of the I-94. So you mail it to them, but don't just mail the card. Mail evidence that you are physically present in your home country, because that is what is going to show as evidence of your departure. So once you mail it, then you should be fine. The next question. Please explain the H-1B cap. Is anyone exempt from the cap? Oh yes, I believe that H-1B currently is only 65,000 annually. This 65,000 is not including the extra 20,000 that is available for foreigners who obtain master's degree from an American university. So they have extra 20,000. So for those ones, they usually immigration will ballot for them first, select the 20,000. Anyone who did not win part of the ballot will be included in the general one, where 65,000 will be taken out. Now, the government, the immigration, USCIS can only approve that 65,000 per year, nothing more. However, there are some categories of people who are exempt from that cap of 65,000. For example, there are some non-profit organizations, not all non-profit, especially if what they do is related to education. There are also some research organizations that are exempt from the cap what that means is that they can petition for a beneficiary all around the year, irrespective of whether the 65,000 cap has been reached or not. And of course, anyone who has previously been on H1, H1B, who is only applying for an extension, is also exempt. You may be illegal. For every non-immigrant, there is a what I can call a grace period of 180 days. But I always tell people, don't take the risk, because even though the law grants that 180 days grace period, the fact that you have to go back to your home country, the embassy can use those periods that you overstay. They can use it against you. They can use it as a ground not to grant you visa in the future. They can use it as a ground to deny your visa or to deny any other application that you may submit to the embassy. Although there is a grace period of 180 days, I will not advise people to take it. I will not advise people to take it. So it's better, as soon as your J1 expires, please make arrangement to leave, except if you have applied for a waiver of the 2-year foreign residency requirement. Next question. Can a secretary or maintenance worker for a church be eligible for an R1 visa as a religious worker? No. Religious worker, the work must be religious employment. It cannot be administrative duties. It cannot be non-religious duties. If the job duties is not religious in nature, the beneficiary will not be eligible for R1. For you to be a religious worker, the specific job duties has to be a religious duties. It cannot be administrative work or maintenance work. No, you will not be eligible for R1. The next question. I'm applying for adjustment of status, but I need to prove legal entry and I lost it. Isn't the US visa enough to prove this? If it isn't, what can I do? Well, if you have your US visa, we can apply for replacement of your I-94. We can also do what is called a FOIA. And in some cases, your visa can also be enough. So every case is different. Not in all cases, but every case is different. But generally, in some cases, the visa may be enough. In some cases, you may need to apply for a replacement of your I-94. And in some cases, you may need to apply for a FOIA so that you can get evidence of your legal entry. The next question, can I participate in another J1 program after finishing my current program? Well, it depends on the sponsor. It depends on what your J1 says. If your J1 authorizes an extension, then you may be able to do it. But what you cannot do is to change your status. You cannot change your status and you cannot adjust your status. You cannot do any of those ones. My J1 visa has a restriction of 2 years before I can apply for adjustment. Can the restriction be removed? In some cases, yes. If you apply for a waiver, usually it's of the United States, then you will need what is called no objection letter from the government of your home country. If you are able to process the no objection letter, you may use that to apply for a waiver. And if a waiver is granted, you may be able to change your status or adjust your status while in the US. But if you are not able to get a waiver, you will have to leave the United States. And in some cases too, if your work is in an area that the US government believes that you may be valuable, the government agency themselves may apply for that waiver on your behalf, especially if your job is in an area that is not underserved area called underserved area. You may be able to get the waiver even without leaving the US. The next question. How does the diversity visa green card lottery work? Well, if you are from a country that is allowed, I think, when is 7? What's today's date? 8. Oh, I think the diversity visa ended yesterday. Yeah, it ended yesterday. So if you are from a country that allows it, you play it, you fill in your information, submit your passport application, and they add you to the pool. So whenever they are ready, they select the numbers, and if you are lucky to be picked among the selected ones, you have they will write you a letter congratulating you, informing you that you have been selected. So that letter will stand in the place of a petition, and on the basis of that letter, you can apply either for adjustment of status if you are in the US legally, or a visa, immigrant visa, if you are abroad. So in any case, you still have to apply for adjustment of status or an immigrant visa through the embassy if you are selected. But again, the fact that you are selected does not guarantee that you will get the green card, because in some cases, usually more numbers are selected than required. Usually they select, I think, about 50,000 or so above the allowed number. This is to leave room for those who may be denied along the line. So, but if nobody was denied, or if the number of people denied were not up to the 50,000, so the applications for green card based on lottery are processed on first come, first served basis. So once they get to the number, that will be it. So you may still have your letter showing that you won the lottery and you may not be able to get the green card. So immigration physical year is usually from 1st of October to 31st of September. So if you are unable to process your green card before 31st of September, following the year that you won the lottery, then the lottery becomes useless. So I believe that was the last question for today. And if there are no other questions, we have come to the end of today's podcast. We intentionally made this open today to allow for all kinds of visa questions. So I believe that we have been able to answer a lot of visa questions. So in the absence of additional questions, we'll be rounding up today. We hope to see you again next week. Remember, subscribe to our channel so that whenever we go live, you will be notified. Also, remember to invite your family and friends, your colleagues, so that they too can benefit from this wealth of free information. See you next week.